Good afternoon. My name is Jeff Nolan. I'm a member of the advisory board for the Legal Issues in Higher Education Conference at the University of Vermont. And on behalf of the UVM Continuing and Distance Education and the Legal Issues in Higher Education Conference Board of Advisors, I'd like to welcome you to the fourth in our series of 6 Legal Issues in Higher Education summer webinars. We're pleased to connect with you remotely and to be able to keep the conversation about the new Title IX regulations going. Today's topic is new regs, new procedures, managing live hearings, cross-examination, and more. Again, I'm Jeff Nolan. We hope to have an engaging discussion today. Please post your questions in the chat for our expert panelists to explore and discuss, and I will read them as we go as appropriate. So please feel free to type in as we go. Our presenters today are Emily Babb, JD. She's the Assistant Vice President for Title IX Compliance and the Title IX Coordinator at the University of Virginia. Welcome, Emily. We also have Debbie Osgood, JD, with us. She's a partner at Hogan, Marin, Babel, and Rose. Hi, Debbie.
Hi, Jeff.
And we have Joshua Richards. He's a partner at Saul Ewing, Arnstein, and Lair. Hi, Josh.
Jeff.
All right. With that, I'll let you all get started, and I'll chime in with questions as we go.
Thank you, Jeff. I'm going to start us off, and I apologize for my croaky voice. I have some allergies this summer that just won't go away. But I'm going to talk about the legal requirements. Josh and I are going to talk about what are the legal requirements in the final Title IX regulations, what are you required to do about hearings, and then what do the regulations allow you to do or give you discretion to do. And what we're going to be talking to you about is principally based on the language of the regulations themselves, as informed by the lengthy preamble, by OCR's blogs, and also by the OCR webinar that was released today on hearing proceedings. After Josh and I go over the legal part, Emily is going to share her experience on the ground, working with hearing panels and hearing officers and witnesses and parties to have hearings and share her wisdom from that as well. So we're going to start by what does the regulation require? And for post-secondary institutions, the grievance process must include a live hearing. Now, for other institutions like elementary and secondary schools or systems, academic medical centers, a live hearing is not required, but for purposes of our audience today, we're going to assume that it is required and that most of you, if not all of you, are college and university personnel in some capacity. And the rules require that a hearing be such that the parties can see each other and hear each other in real time and ask each other questions. I think it's important to remember that the hearing process only applies to sexual harassment that has come within the scope of the new Title IX regulations. So it needs to meet the definition of sexual harassment in the new regulations. There needs to be a formal complaint to either the Title IX coordinator or someone with authority to take corrective action. It also needs to be in the education program or activity in the United States. So all of those kind of narrow the scope of what could be subject to a hearing, but those are the prerequisites before going on to the hearing requirement. In terms of the hearing structure and what the hearing actually looks like, one of the things that we would recommend is as you're thinking about what you want to do with your hearing process, you may want to put some of that in writing and share with the parties and with the hearing panel so there's a clear understanding and expectations about what to expect from the hearing process. And the regs really do not prescribe what type of hearing process you need to offer. You can have a panel of several members. We've seen panels of 3 to 5 university officials. You can also have just a single hearing officer, or you could have a hearing panel that has a chair, an administrator, that serves in that function. So you really have some discretion about whether to have a hearing of one or a hearing of several people. And at the hearing, you're going to, obviously the participants are going to include the parties, the witnesses, the advisors, the hearing officers, obviously, and then there may be university personnel that will be there to assist with the logistics. Another point to consider as you're thinking about how you want your hearing process to run is how is the panel, if it's more than one person, going to make a decision. And again, the regulations don't require that it be by a majority vote or that it be unanimous. That's something that is up to you and your community to decide how best to handle. I also wanted to make a note here that we are using the term hearing panel and hearing officer to refer to the officials, I guess, that are charged with conducting the hearing. If you listen to the webinar from OCR that was issued today, one of the first things that the Assistant Secretary says is that non-decision makers include hearing officers, which kind of threw me for a loop. But then I realized that what OCR is referring to is the person that serves as an administrator and runs the logistics of the hearing. But for our purposes, we're talking about the hearing officer and the hearing panel being one and the same as the decision maker. And the decision maker, there are several specific requirements in the regulations. It cannot be the same person as the Title IX coordinator or the investigator. You have to provide very specific training to the decision makers. The person cannot have a conflict of interest or bias, and needs to know how to run an orderly hearing and make relevancy decisions. What the regulations don't require is that the hearing officer be either an internal person or external. They don't require that it be an attorney, and so they also don't require that the same decision maker, that there be a single decision maker for both the determination of responsibility and the sanctions decision. The Title IX training that's required, I think that this is interesting because I think most schools have been training folks involved in their Title IX processes and investigations and adjudications for many years under BAWA. But this is the first time that the Title IX regulations themselves, as opposed to policy guidance, require that there be training for individuals that are involved in your hearing and adjudication process. And this applies to folks that you are using internally as well as anyone that you hire externally. Another important point to keep in mind is that the hearing training that you provide for decision makers must be posted on your website and kept up there and the records about the training have to be maintained for 7 years. We mentioned that the hearing officer is not supposed to have a bias and is supposed to act in an impartial way, may not rely on sex stereotypes. And then you'll see on this slide a longer list of the specific content that must be in your training for hearing officer, and I'll let you read that. But it's obviously tailored to the new requirements in the final Title IX regulations. The duties of the hearing officer, I think that the main duties are to kind of oversee the hearing and make sure it is being conducted in accordance with the school's policies as well as the Title IX regulations. But the hearing officer beyond that is the person or persons that's responsible for making the determination of responsibility using the preponderance of the evidence standard. And if that person is charged with making sanctions decisions, they would also make the sanctions decision. Josh is going to talk more about the duty of the hearing officers to make relevancy determinations at the hearing and how the hearing itself will go. So we did get a question. I was just going to jump in here. Can the hearing officer be an arbitrator or a panel of arbitrators? And I guess my answer would be that as long as that person, regardless of their title, is an arbitrator or not, as long as they are otherwise qualified to serve according to the requirements we went over, then that they could serve. I don't know if Emily or Josh has a different take on that. Okay, the hearing location. So I want to start by saying that if either party requests that the hearing be conducted in separate rooms, the recipient has to accommodate that and provide separate rooms with technology so that the parties and the witnesses and the decision makers can hear and see each other in live time. Beyond that, though, it is up to the recipient to decide whether they want to conduct the hearing on site in a single geographic location, or whether they want to conduct it virtually. And clearly, a lot of schools are doing it virtually with the COVID situation. Emily is going to talk more about the tech. It's hard. It gets very distracting when you see questions, so I'm not going to pay attention to them right now.
So I can pose it for you, Deb, so you don't have to read it. So the question is a good one, and one that I know you know the answer to. The question is, so can the decision maker make both a finding of responsibility and issue sanctions?
And the answer is yes. The regulations provide that you can have either a single decision maker, and by that I mean single person or panel, that makes both the finding of responsibility and the sanctions determination, or you can have separate decision makers make those decisions, but the final written decision has to include both decisions in one document. And I'm sure Josh is going to cover that a little bit later.
Okay, I'll leave it at that then.
Okay. Emily's going to talk a little bit more specifically about some of the technology that she's used at UVA for hearings, but I wanted to note that the training, the technology, the hearing itself has to be recorded, or there has to be a transcript, and the recording can either be an audio hearing or a visual hearing, like a Zoom webcast or something. As I said, that's kind of the next few slides are going to overlap a little bit with what Emily's going to talk about, but just in terms of thinking about getting ready for the hearing, this is kind of a helpful list. I would highlight on this list the last point, which is have at the ready, if you are a hearing officer or someone is a hearing officer, to have at the ready the number and email for the Title IX coordinator and the general counsel in case there are questions that come up live time in the hearing itself. And in terms of pre-hearing review and preparation, as a hearing officer, you have to first review the report, obviously thoroughly review the evidence, and then look at the policy that applies from that school and what the hearing procedures are, and start thinking about questions that you might want to ask in areas of clarification that will be needed to be clarified at the hearing itself. The hearing officer really has very ample authority. We say here complete authority about how to run the hearing, provided obviously that it complies with the Title IX regulations and with the school's procedures. Any rules that the hearing officer has to apply equally to both parties, but it is expected that the hearing officer or the panel will be the one that's kind of running the hearing and making sure that everyone is maintaining order and decorum and really setting the tone of the hearing. And finally, I think we mentioned this already, that you have to record the hearing, and then also that your training materials must be posted on your website and then retained for 7 years. I'm going to kick it over to Josh.
Thanks, Debbie. So I'm going to jump in to the actual hearing itself, and how are we going to sort of walk through? We're in the room, and what are we exactly expected to do? Well, the first thing to keep in mind is that I think as we've learned from the earlier webinars and from reading the regulation, at the end of the investigation, the investigator is going to make available to the parties and their advisors all of the evidence that's been gathered that's directly related to the allegations in the formal complaint. And that's going to give the parties the opportunity to make arguments about, what that evidence means, about what of that evidence, in addition to being directly related, is actually relevant and should be included in the final investigative report. And so that evidence is going to be familiar to the parties. It's possible that when that evidence gets reviewed, the investigator does additional investigation because the parties realize there's something that isn't there that ought to be. But that corpus of evidence is going to get completed, and that's the corpus of evidence that has to be available at the hearing. It's not just the evidence that we're going to rely on, as we had under VAWA, and it's not just the evidence that we think is relevant. It's all the inculpatory and exculpatory evidence that was gathered is available, and that is in part because the parties need to have the ability to make arguments to the hearing decision maker about the relevance of that evidence. It's certainly possible that an investigator could conclude that evidence wasn't relevant and not include it in the report, and then the hearing officer make a different, a contrary determination about that evidence. And so we need to have all of this evidence available in either hard copy or in some sort of online format like Box, so that the parties can refer to it at the hearing officer can refer to it at the hearing, and all of the evidence that's been gathered is sort of accessible for that use at the hearing. Well, all that relevant evidence sort of goes into the hopper, and what comes out? Well, what comes out is whatever finding is dictated by the standard of evidence that you use. And unlike under the Obama administration, the regulation permits us to choose between the preponderance of the evidence or clearly convincing. And I think we all are very used to working with the preponderance. Clearly convincing is an evidence standard that lots of institutions have used in the past, particularly for faculty matters. And so most of us are familiar with that as well. We can use either standard. The catch is, whatever standard we use, we have to use for all resolutions of formal complaints of sexual harassment. And so we can't use one standard for faculty and staff and one standard for students. This can be particularly tricky in the event that you have a collective bargaining unit that is bargained for clear and convincing evidence. That creates a ratchet up that would require you to use clear and convincing for everything. You could be in a situation where you have competing ratchets because you may be in a state that requires you to use preponderance of the evidence, which would then ratchet down all of the other proceedings. And so reconciling this rule with existing obligations and state laws is one of the things that I think is going to be tricky for some institutions. Those that have already adopted preponderance for all proceedings, which I think many institutions have, will have less of an issue with this. So as they were through the process, although we're not going to talk about earlier in the process today, the parties have the right to select an advisor of their choice to attend the hearing. This is the only part of the process that an advisor's presence is required. And we'll talk about in a minute the reasons for that, which have to do with cross-examination. But for purposes of this slide, the things that are important are we really have no ability at all to limit the party's choice of advisor. And I think a lot of institutions have had sensible rules in the past around saying things like, well, you have the advisor of choice, but you can't select a witness in the proceeding, or you can't select somebody who has some sort of significant connection to the facts. And I think the regs don't include any of those provisos. And in fact, when Candace Jackson briefed the National Association of College and University Attorneys on this topic, she was pretty clear that this just isn't something that schools can limit. We can counsel parties that selecting certain advisors could have adverse consequences. Things like if a principal witness is sitting in on all the interviews with both parties, their testimony might be tainted, and that might inform the way the hearing officer views it. But we can't say no. And so that's something that's really important to keep in mind. We can limit the way that advisors participate, both through the process, which again, we're not going to get into that today, but also at the hearing. The only thing that we have to allow the advisor to do at the hearing, I should say the only things, are we do have to allow the advisor reasonable opportunity to confer with the person who they're advising. And we have to permit, we in fact have to compel the advisor to conduct cross-examination at the hearing. And we'll talk about that in a little bit. Apart from those two things, we don't have to give the advisor any additional role. We certainly can let the advisor give opening statements. We can let the advisor address the hearing officer. We can let the advisor conduct direct examination of the witness, but we don't have to let the advisor do any of those things. So this advisor, if selected by the party, will do all of those things at the hearing and conduct cross-examination. If a party doesn't have an advisor for a hearing, then we have to provide them one, and that advisor is at our discretion. We select that advisor, and that advisor isn't subject to the same sorts of conflict of interest rules, bias rules, etc., that other people in this process, like investigators and hearing officers, are. In fact, I think the department would say, we sort of intend for this person to be an advocate of sorts, and so they can have a bias, particularly for the person they're advising. But the role of the provided advisor at its very basic level is to resolve a conflict in the regs, right? The conflict is that, on the one hand, no one who gives testimony in the hearing can give that testimony without it being subjected to cross-examination. That is an absolute table stakes requirement. On the other hand, you have the department saying, well, we're never going to let the parties cross-examine each other. And so you have this conflict there because the one party's statements have to be subject to cross-examination, but we're not going to let the other person do it. And so how do we resolve that? Well, they could have resolved it by having the hearing officer do all of the examination. In fact, many commenters suggested that they do that. That isn't what they chose to do. And instead how they solved that conflict is to say, well, we're going to have a person who participates whose role is essentially to ask questions and literally just be a person who isn't the party. And so, you really could almost, I joke, but you could have, like a dummy that the party records their question into, and then the dummy plays it, and that would almost satisfy this requirement. And maybe it actually would satisfy it, who knows. But that's really, when you think of this advisor and what you're required to do, that's what they're required to do. They're required to ask the questions the party would ask if they could ask them. Now, can the advisor do more? Of course they can do more. Many parties will hire a lawyer. The lawyers will be extremely facile at cross-examination, and they will ask much better questions than the party ever could have asked on their own. And that's permitted. But when we provide the advisor, our obligation isn't to provide legal advice. It isn't to provide somebody who's going to do a better job than the party. It's just to provide a person. So that raises a lot of difficult questions, right? Because the first thing that comes to mind here is, but what about the equity, right? What about a party who hires an $800 or a $900 or a $1,000 lawyer, an hour a lawyer, and brings that person in? And on the other side, we're providing an advisor who's just, basically, a dummy who's playing back recorded questions. Does that seem fair? Well, it doesn't. It doesn't seem particularly fair. But on the other hand, that person's hiring that lawyer for the whole process, and the provided advisor that we're coming up with is really only for the hearing. And so you have to sort of think through the consequences of, well, if we're going to provide a lawyer in cases where the other party has a lawyer, is it just for the hearing, or is it for the whole process? And what are sort of the implications of that? Are you upping the sort of confrontational nature of the hearing? Do you want to provide a lawyer only when there's a lawyer on their side? Do you always want to provide lawyers? Do you never want to provide lawyers? It's a difficult question that's sort of hard to square with institutional missions, no matter how you slice it. But if you're not going to provide a lawyer, do you want that person to be internal or external to the university? Do you want to provide options to the person? I mean, we do get to select who it is, but do we provide a panel so they pick from 3 people? do we want that person to do more than just cross if we have a process that allows advisors to do more than just cross? And I'll talk about in a minute, this idea of what happens when a party doesn't show up and we still have to have cross-examination. How does that advisor formulate those questions? Do they need to have some sort of a specialized skill to be able to do that if they don't have the assistance of a party? So those are all, I think, very tricky questions. This is among the most difficult parts of the regulation to implement. We haven't seen how this is going to come out yet, and Emily may have, I'm confident Emily will have some really excellent observations about this. But I think we're all sort of waiting to see how much of an issue this will actually be. How many parties will show up for hearings without advisors? The other thing that I'll say about this is because we have to provide this person, one of the process points that I think is a really good practice is to amend the procedural pre-hearing process that you use, which we're allowed to do so long as it's equitable, to require parties to let you know at least a few days in advance whether they intend to bring their own advisor to the hearing. You really want to know if they're not going to. You want to have somebody lined up, hopefully with enough time to read the file and figure out what questions make sense, to get in touch with the party prior to the actual day of the hearing. You don't want somebody sort of rolling into the hearing and saying, oh, I forgot to tell you I don't have an advisor, I need you to provide me one. That's, I think going to be really disruptive.
So Josh, can I interrupt you with a question?
Sure.
So the question is, if they request an advisor for evidence review and response, or response to a finalized investigative report, but prior to a hearing, are we required to provide one?
The only time that you're required to provide an advisor is for purposes of cross-examination. Now, where that can get tricky is, they are entitled to the advisor of their choice, although they're not entitled to indentured servitude. So if you have people in your community who regularly serve in this role and somebody asks for an advisor, you could connect them with the resources of who those people typically are, and they can work out with those advisors whether or not that advisor wants to be their advisor or not. But that specific part, evidence review and response to a report, is not a part of the process that we are required to provide an advisor for. Thanks for that, Jeff. That's a good question. So now we're going to get into the actual cross. At the live hearing, essentially the only absolutely required feature is that each party's advisor is permitted to ask cross-examination questions of any party or witness upon whose statement the hearing officer might rely. And so that cross has to happen live. It has to happen orally and directly and in real time. It doesn't mean, as Debbie said, that everybody has to be in the same room, but everybody has to be able to see and hear each other. And it can't be sort of filtered in any sort of way other than when a question is asked, the mechanics of the process are that the hearing officer, I suppose everybody at the hearing, hears the question. Nobody says anything until the hearing officer has made a ruling as to whether or not the question is relevant and not for some other reason impermissible. And then only after the hearing officer has made that determination does the witness answer. Now, I would submit that this serves sort of two important functions. The first function is sort of, the obvious and stated one, which is to determine relevance. The other one that I actually really like is, part of the criticism of this process, to which I think OCR has been receptive, although, hasn't changed its mind, is that these are going to be really confrontational processes, and particularly when you have aggressive criminal defense attorneys, no offense if anybody on the phone is a criminal defense attorney, that this sort of rat-a-tat nature of really good cross-examination will be particularly trauma-inducing for all kinds of reasons, not just to complainants. And what this allows for is sort of what I think of as sort of a civilized pause. right? The question gets asked, everybody gets to wait a beat, you get a determination on relevance, and then the answer comes in. And so it does protect a little bit against that sort of high-paced, aggressive questioning style that I think most of us think about when we think about the sort of negative features of this kind of a process. So what about that relevance? There really are only 3 exceptions to the kinds of questions that parties have to answer if they're relevant. And of course, relevance, the department tells us, is, given its common meaning, it's, whether or not it's more or less likely to make a material fact true. And so the exceptions to that are, we're not allowed to pierce what is essentially a rape shield protection. We're not allowed to pierce privilege. And we're not allowed to let evidence in that would essentially be hearsay. And I'm going to explain that last one in a minute. But first, let's talk just a little bit about rape shield protection, right? So basically, questions about the complainant's prior sexual history or sexual disposition are per se not relevant. Even if they would have some bearing on whether, we could disagree about that. We're just like, there's a categorical rule that unless the question is offered to prove someone other than the respondent was the perpetrator, or that there's sort of a specific circumstance that goes to consent between the parties, those questions about prior sexual history are out. So what about this hearsay issue? So what the department really wanted to do here was guarantee that all evidence that comes into these procedures for consideration by the hearing officer be subject to cross-examination. That's sort of the paramount procedural protection that the department's seeking to implement with these rules. So any party, and this is the rule, any party who does not submit to cross-examination their statements are precluded from consideration by the hearing officer. And statements here is a really broad term. It basically means anything that the party has said, with a limited exception, via text message prior to the investigation, via an oral conversation with the complainant the day after the event happened, whether it's a statement to the investigator, whether it's a SANE nurse's notes in an exam, anything that conveys a fact, an assertion of truth, is a statement that's excluded if that person doesn't submit to cross-exam. And the submission to cross-examination is all or nothing. What that means is the person comes to the hearing, they sit down, and they answer every question that the hearing officer says is relevant. And if they do that, then their statements can be considered. If they don't submit to cross-examination, then all their statements are out. Now, one of the things that is concerning about this, of course, is that some statements are incredibly probative, right? You got me, I did it, I engaged in that conduct, says the respondent during the interview with the investigator. The natural question here is, well, you can't have intended that not be considered. And the answer from Department of Ed is, well, yes, we did. If the respondent doesn't show up for the hearing and they don't submit to cross-examination, then that admission cannot be considered by the hearing officer in determining responsibility, which seems bonkers, to me at least, but that is the rule. There is a really important caveat to this, and in I think response to a lot of people's questions about this, the Department of Education did blog about this, and the question is, well, what about a statement that is itself harassment? What about when the professor emails the graduate student repeatedly and says, if you go on a date with me, I'll give you a better grade, and the professor then goes into the hearing and says, well, I'm not going to submit to cross-examination, and so you can't use my statement to my graduate student. And what OCR has clarified is to say that where a verbal or written statement is itself the thing that is alleged to have been the harassing behavior, that is not an excluded statement for this purpose.
Hey, Josh,
Actually,
can I ask you a question?
Yeah, and before I move on, Jeff, let me just say one more thing about that, which I wanted to say. This is an incredibly difficult issue to implement in sort of operationally, right? Because we're going to get this hearing report, and the hearing report is going to have all the relevant evidence in it, right? The investigator has made a determination that we're summarizing all the relevant evidence. It's here. The investigator has no idea if the people who gave them the relevant evidence are going to testify. So the hearing officer is going to read the investigation report. They're going to learn all about the case, and they're going to show up at the hearing, and they're going to learn that in one of the meetings, the respondent admitted to the conduct. Well, the respondent doesn't show up for the hearing and doesn't cross-examine. The hearing officer is absolutely expected to forget and not rely on that, and cannot rely on that. It's a big ask, but it is the ask that Ed is making. So, sorry, Jeff, what was your question?
No, that's okay. So I wanted to, because it is counterintuitive to say the least, have you re-emphasize the point around what it means to submit to cross-examination and what it means if someone doesn't answer even one question that the hearing officer determined was relevant.
This is like when Pippen alley-oops Jordan. The answer is that if the person refuses to answer even one question that is relevant, the hearing officer cannot rely on any of their statements. And listen, this isn't going to happen in practice, and I'll tell you why. If the respondent is represented by a competent advisor, they're going to sit down and they're going to obfuscate, right? They're going to say, I don't remember, or they're going to say, that isn't really how I remember it, but I'm not sure. And the reason for that is, once they don't answer that question, all of their statements, including refutations of the allegations, are out the window. And so the only record that the hearing officer has is the complainant's allegation. And you could think of a hypothetical in which the complainant was incapacitated and there was no memory of anything and the only evidence was the respondent's, in which case maybe a respondent would be able to take advantage of this and abuse this rule. But in most cases, the respondent will have a strong incentive to submit to all cross-examination. But Jeff, your question is right. It is counterintuitive. Them's the rules.
I think I'm going to say that if they attempt some answer, even if it's not a very good one, it's kind of evasive, what have you, they've submitted to cross and we continue. I don't say we're throwing the case out at that point. If they refuse, that's when we're in trouble.
Yeah, and I think when they refuse might happen, Jeff, in a situation where there are criminal implications and counsel just instructs them not to answer. And that may happen from time to time.
Yep.
So that exclusionary rule doesn't apply to questions asked by the decision maker, right? So the hearing officer also has a role to play in the hearing. And, we've talked about the required elements. There are certainly many, many potential elements to the hearing where the decision maker can ask questions that they want to ask, but those are not subject to that exclusionary rule. We've talked about this idea of whether or not these statements contained in the investigative report are also subject to this rule. They absolutely are. And, very briefly, I want to just talk about the effect of the failure to appear at the hearing. If a respondent doesn't show up at the hearing, or any witness, or really any party, I should say, we cannot compel them to do so. And so if the party doesn't show up, their advisor can come and still conduct the cross. And in fact, we want them to do that because we need somebody to conduct the cross so that we can consider the statements of the other witnesses. And if neither the party or their advisor show up at the hearing, we have to essentially provide an advisor for the sole purpose of cross-examining the other parties and witnesses so that their statements can be subject to cross. And that's a very strange configuration, but it preserves the rule we talked about earlier, which is that of paramount importance is that every statement offered at the hearing be subject to cross. So with that, I'm going to just wrap things up very quickly here and talk about the written determination at the end. As Debbie mentioned, we can have two decision makers. We can have a responsibility finding by one decision maker and a sanction and remedial measure sort of decision made by somebody else. And the caveat to that is that the written determination of outcome has to be one document. And so what we have to do is get those decision makers together behind the scenes, get a responsibility finding with facts and reasons from the first decision maker to the sanctions decision maker, let them review that, incorporate their portion, here are the sanctions, here's why, put all that together into one notification, and then send it simultaneously to the parties with instructions about how to appeal. Seems a little stilted, but that's what we're required to do. We don't have a ton of time because I've gone over, and I apologize for that. The one thing that I want to say about this before we move on is that this process makes using impact statements a really poor fit because it doesn't provide the opportunity to let the parties know what the finding is before there's an outcome. And so if you want to continue to use impact statements, you need to be creative and you need to be prepared to have them have a little less oomph because you're going to ask a respondent to talk about things that might affect the outcome before they know the outcome. You're going to ask a complainant to talk about the impact on them before they know whether there's a responsibility finding. Emily and I talked a little bit before this. You can use sort of a sealed envelope approach on this, but the department just wasn't thinking about impact statements when they created this process, and so you really have to either let go of that or be prepared for them to not be as effective. You have to offer both parties an appeal. The appeal bases are set by the regulation. Those bases can be supplemented as long as the bases are equally available to both sides. A question that I get a lot is, can we offer different appeal bases to students than we do to faculty or staff? I don't see anything in the regulation that would prohibit that. But this is the department has sort of laid everything out for us here in a pretty prescriptive way. There's not a lot of decision points to make when it comes to the appeal process. So with that, I want to turn things over to Emily and let her talk about how UVA has cracked some of these nuts.
Thanks, Josh. Thanks, Debbie. I wanted to start with just some highlights here and to really note that colleges and universities do have options. Looking at the regulations, they're very prescriptive, but as Josh discussed, oftentimes you can do more than what the regulations require, and there is a great amount of flexibility. Here we talk about some of those options that you have kind of in that hearing process. And the first is to think through that the regulations give the flexibility to permit an investigator to make a recommended finding as long as the decision maker is the ultimate decision maker, whether that be the panel or a single hearing officer. And this might give an opportunity for a college or university to put some kind of guide rails and guidance around what are the issues that will really be highlighted in a hearing. So this could be a good tool to keep a hearing from turning into a mini trial at every single time. Similarly, you can establish rules and procedures around when to consolidate allegations and hearings. And most importantly, what remains in the toolbox is the rules of decorum, which the college and university can establish. And I'll talk a little bit more about that. I think Josh's point around the decision maker and impact statement is really important, right? This is an area where, because it is the decision must be communicated through that written determination, both with regard to responsibility and sanctions at the same time, there is a little bit of clunkiness on how impact and mitigation statements are going to be provided. Definitely one option is the sealed envelope or the added box link with the information, so that it's really only provided, when they crack the seal and are moving on because there's been that finding of responsibility. So let's talk a little bit about the policies and practice. As you all know, August 14th is just around the corner, 22 days to be exact, not that we're counting. And it's really important to think beyond just the creation of the policy and consider how your institution will implement the policies and procedures. First on my mind is training. As Debbie discussed, not only is training required, but the regulations are clear on who must be trained, on what they must be trained on, and what you need to do with those training materials. You have to train everyone: investigators, Title IX coordinators, decision makers, appeal officers, informal resolution facilitators. when you're thinking about staffing these roles, those individuals need to understand that they're going to need to participate in pretty extensive training. The commentary from the Department of Education says that you can expect 8 hours the first year and ongoing training. Really getting up to speed is going to take a lot of time for these different roles. So as you're putting your policies together, your hearing officers, your panel members, think about their roles at your institution and that they must meet and use these online or this ongoing training requirements. Debbie had a slide that talked about what those requirements are, so I'm not going to go in depth on those. But one thing that you can consider is how to move forward with training in a way that is most efficient. So, a best practice or something to consider would be working with other colleges and institutions of your like size in your geographic region to come up with a training plan that you can share. So I know that we're looking to our peer institutions to work and collaborate very closely so that we can really rely and work together in a way that will meet these needs and moving forward. But whether you're an institution that's never done a hearing or one that has held many hearings, really being prepared is key. As the Title IX coordinator in an institution, I can tell you it is possible to do hearings. You can do it. We've had hearings virtually post work from home, and it seems like an insurmountable task at times, but I can assure you that it's not. In today's Department of Education webinar, the department reaffirmed that hearings may be conducted by the university, by using outside entities, or through a consortium to provide efficiencies and streamline processes. So there are a lot of options for how you proceed. Some things to think about when you're preparing for that hearing are your notice of hearing. Make sure your notice is clear. Explain who will be present and what the parties can expect. I can encourage developing an FAQ to answer some common questions and provide that along with the notice. Some questions to answer may be a description of the physical or virtual space, an estimated time for a hearing, the nuts and bolts of how are you going to ask questions if you're not physically present in that room. The logistics of your hearing are largely going to be dependent on the format. So if it's an in-person hearing, you're going to think about how you're moving people in and out of your spaces. Where are they going to be if they need a private space to confer with an advisor? When you're choosing the location of your hearing, it's important to note your space and any restrictions you may have. This could be new based on any social distancing requirements that you now are needing to navigate. One practice that I strongly encourage is as we've held hearings with in-person and virtual, it's important and can be very helpful to have an individual who's not the chair or of the panel or the decision maker who can assist with logistics. Debbie talked about that earlier. A trusted assistant, a deputy Title IX coordinator, or an investigator not assigned to the matter could serve in that role. They should be familiar with the parties and advisors, the witnesses, the space, the timing, and can help move people through this process. Having an assigned individual who can navigate people in and out of an actual or virtual room will allow your panel, your decision maker, or your chair to be able to continue to make those decisions that are the most important. Similarly, with both in-person and virtual hearings, you need to have a process for parties or witnesses to request accommodations, both related to disability and language assistance. This was noted in today's Department of Education webinar that the obligations to comply with all of the civil rights laws remain. And they again reiterated the need to ensure that appropriate accommodations are provided. Working with your Student Disability Access Coordinator or ADA coordinator along this process is very important. But let's talk about virtual hearings, because I think that's where we're all really thinking about right now. As we're bringing colleges or students back in some form, whether it be in person or through virtual means, I think virtual hearings are really important. And it is a silver lining of the Title IX regulations that they did acknowledge that a hearing may be conducted virtually. The regulations provide that the decision to have a virtual hearing really rests with the institution, so you can ensure your policy is written in a way that allows you to make that decision and not be forced moving forward into an in-person hearing. Some things to consider around format are your technology. Is it available at no cost? What if your parties do not have access to technology or a quiet space? You may have to schedule your hearing around that, or provide a private space in your office where they can access that even if it's a virtual hearing. Can you accommodate requests by more than one or more parties to not view the other? The regulations require that the technology allow you to view the party and during the time of the hearing, but there may be parties who don't wish to do that. So there are some technology you can utilize to allow the user to pin the video of the chair or the decision maker so they can incorporate and work in that way. As you're thinking through logistics, you might consider what features of your technology you need to disable. Do you want your parties to be able to chat to everyone? Upload files? Have you password protected your meeting? These are all those Zoom questions that we're thinking through. And making sure you have the technology that allows you to facilitate the hearing in a way that's necessary. So one thing you can do is set up multiple rooms as part of a virtual hearing. You'll need a room for your hearing, a breakout room for each party and their advisors, a deliberation room if you have a panel, a room for witnesses to wait, a room for your court reporter if you're not in session, and maybe even a room where you can consult with the Title IX coordinator or university counsel. Earlier we talked about having that number to the Title IX coordinator. You might be able to also have a room where you can come and have that face-to-face virtual conversation with them. And I know we're moving short on time, and we want to definitely make sure that there's an opportunity for questions here. And so I really want to stop and make sure we can move over to that direction. One thing I want to make sure we don't leave behind are those rules of decorum, and really thinking through what that means. This is an area where you can establish clear guidelines for parties and advisors, and more importantly, if parties and advisors are not following those guidelines, particularly advisors, an opportunity for you to remove the advisor if necessary. We all hope for a very cordial hearing, but we know that this is a very difficult time and can cause conflict. So having really strong rules of decorum can be very beneficial to make sure that hearing stays on track. I encourage you share those rules of decorum both with the notice of hearing, the day of the hearing, publish them on your website. Make sure that your advisors, whether they be external or an advisor that you've provided, knows what is expected of them when they're participating in the hearing. I see we have quite a few questions in the chat. So Jeff, I want to make sure that we have an opportunity for you to ask some of these questions around the nuts and bolts of what's happening in the hearing. So I'm happy to send that back to you.
Great, thank you, Emily. I'm gonna pose the first one to you because I'm interested in the practical side of this. I'm going to broaden it a bit from what it's labeled as in the chat. So lots and lots of schools are deciding to use hearing officers that are brought in from outside of the institution because of expertise they may have, particularly smaller schools. But they're using internal folks to make the sanctioning decisions because they want sanctioning to be a reflection of the institution's values. So that split is common, and Josh talked about the need to have one decision even where that's the case. My question for you is, from a practical perspective, how do you see getting information to the sanctioning officer about the matter so that they can reasonably make a good, well-reasoned judgment about what sanction is appropriate?
Yeah, that's a great question. I think this is a really important and difficult question to answer too. In speaking with colleagues across the country, we have a variety of different options as we're looking at that particular scenario. I've heard institutions say we plan to have the internal person who will be making that sanctioning decision participate in the hearing throughout the entire process. While they won't be discussing the responsibility, they want to hear everything. Other options could be to make sure that they have access to all of the information. It's that time difference between the decision with regard to responsibility and sanction that makes this very tricky. The department has said we need to make sure that those determinations are done in a timely manner, although that is not defined as what timely is, and I think we can all have probably different interpretations of what timely would be, but really making sure that there's not a gap there. So I think when you're looking at who would be responsible for sanctioning, if it's not your decision maker and you utilize that external decision maker, internal person decision maker with regard to sanctions, is really making sure they're in close communication and have access to all the information to be able to make that determination. Thinking through what they need to know to be able to look at the remedies and potential sanctions, because in the end, what they need to consider is how they're going to address and ensure that continued opportunity for the complainant in their educational opportunity.
Yeah,
Debbie,
thank you,
or
Emily. That's much.
to add?
Okay, thank you, Emily. That's very, very helpful. And the baseline is it's not prescribed. We just want to be reasonable about what our sanctioning officer can defensively say they relied on in making the decision that they did. It might be more efficient to have them at the hearing. It might be more efficient to let them review matters afterward, but they're going to have to see what you think is appropriate. Question about cross-examination of witnesses who are not parties. We typically think of cross-examination as being an adverse interaction. What if the witness is not necessarily adverse to anyone? Are they still being subjected to cross? Josh or Debbie?
What do you think, Debbie?
I think yes. I don't know whether you call it, sorry, I don't know whether you call it cross-examination or questioning, but I do think that they are subject to questioning.
Yeah, I agree. I think, you know, the whole idea here is that every statement that's offered is subject to questioning to test its veracity. And you don't have to exercise that choice, right? You can waive your right to cross any witness, but certainly the right is there. I agree with Debbie.
Yeah, and the idea is that cross-examination has a baggage around it of courtroom dramas and lots of yelling, but really it's just a phase of a trial when questions are being asked by one party of someone else in a particular way. In our way, it's the party's advisors get to ask those questions of witnesses, parties, whomever. So I think it's going to fit squarely within it if they answer questions posed by the advisors. Yeah. Those are the questions we have. Parting comments. I'm going to start with Emily.
I told Josh and Debbie, you can do it. We can do it. You've been doing hearings. I think a lot of institutions have been doing hearings and to throw everything out. So I always want to say that there are good points in the regulations, meaning that there are still thought around these issues, and a lot of the work that your colleges and universities are doing aligns with the new regulations. And so I'm always here to say we're doing it, and we can continue to do it. And 22 days will be here very soon.
Josh or Debbie? Yeah.
I was just going to add that I think, excuse me, I think the dust hasn't fully settled in this area. We're waiting to hear what's going to happen in the court decisions challenging the rules. So, you know, we have to obviously plan to comply with them. But as I said, I don't think the dust is fully settled.
Josh, get the last word.
I agree with Debbie. I get asked all the time, what's the best practice with this? And, you know, the answer is that a lot of these things are things we've been doing for a while, and we know what the best practices are. And a lot of these things nobody's really done that much of. And so we're going to have to do them for a year or so and see how they work and figure out what the best approaches are. And I think I'm grateful to have been on this panel with Debbie and Emily, who know so much about this. And I think we're just going to keep learning from each other and the people who you know, are actually doing these processes.
Good. Well, thank you all, and thank you to everyone for joining us. We have the next webinar in our series on August 7th. It's going to cover informal resolution and restorative practices under the new regulations. I'm looking forward to it. I hope you are as well, and you'll join us with that. And a virtual round of applause for our presenters. Thank you all so much for your efforts and the work that you do. Thanks, everyone.